Welcome to the FAU Libraries Fair Use Week 2022 webinar, Copyright and Fair Use, Basics, Facts, and Myths. My name is Christy Padron. I'm the Scholarly Communications Librarian here at the FAU Library at the Boca Raton campus. I see we got a few people in here. If you'd like, feel free to introduce yourself by your first name and your major, and then I could be sure that I could address some things specific to your area of interest or your topic, or even something that you're doing right now. And then that way I could answer any questions you may have and how this may help you with your copyright issues. So thank you for being here today for this 50-minute session. I like to call this also Copyright Basics for Anyone. So this is really intended for a general audience here at FAU, whether you're a student, you're an undergraduate or a graduate student, or even an instructor or professor. I'd like this presentation to focus on any basic questions you may have about copyright. So today's learning outcomes will be to discern the benefits of knowing about intellectual property. So I will describe very briefly three types of intellectual properties that are out there. Then we'll define copyright and what its rights and protections do for creators. So whether you do graphic arts, whether you write, paint, or even write scholarly journal articles, or you're curious about the copyright over your thesis, we'll describe what protections you have for those kinds of works. And then we'll identify what fair use is and what it allows you to do with other works that have copyright protection. If you have any questions, feel free to put them in chat. I can answer them as I go along, since it doesn't look like we have a big crowd here today, and I could spend more time with each of you and the questions you may have. Just for some housekeeping, we will have a quiz at the end of this presentation. I'll provide the URL to it at the end. There's also a QR code, so you could use your device to take a picture, and it will take you straight to the Google form that you can get your quiz and get your certificate of completion. Also, this recording will be provided on the FAU Libraries YouTube page. So if you go to YouTube and do a search for FAU Libraries, you can find the recording for this article, hopefully tomorrow or within the next couple of days. So with that, we can get started. Just a quick disclaimer, the FAU Libraries and its faculty, staff, and administration are not attorneys and cannot interpret the law. And this information is provided for educational purposes only and does not substitute for advice for legal counsel. So we really want you to have some information to copyright so you could learn more as you need and then get extra help as you also see fit. Copyright in the news. Copyright frequently makes the news with high-profile court cases that seek damages. The rapper and recording artist Drake was recently sued by a jazz musician's estate and family because they felt that he had sampled some of their deceased relatives' music and maybe sampled too much. That meant that it was copyright infringement. They took him to court, and the court sided with Drake, saying that what he did was not infringement, and I think fit the definition of fair use, which we'll talk about a little later. Then you got this picture of that couple there, black and white photograph of the couple with the puppies in their hands. And then the one to the right of it, you see like a color image of the same couple. Well, kind of is, kind of isn't the same couple with the puppies. That's a case of where the photographer, Art Rogers, had sued this artist named Jeff Koons, who took his photograph and kind of like rendered it a little differently to make a statement about materialism and pop culture. So that case went to court. The photographer wanted to sue for, I guess, damages, and they ended up settling out of court for an undisclosed sum of money. Then another recent high-profile court case had to do with Google, our favorite search engine, and Oracle America, that writes JavaScript and other computing languages. So Oracle initially took Google to court because it claimed that Google had misused its JavaScript code for some of its functions. So it bounced around in court for a few years. One decision weighed in favor of Oracle, then Google had contested it, and then it weighed in favor for Google, and it went back and forth until it reached the Supreme Court. Then in the spring of last year, the court actually sided with Google, saying that their use of Oracle America's JavaScript actually was not copyright infringement. So these three different examples really illustrate that copyright applies to many types of creations and intellectual property. And we'll go in and describe the types that get copyright protections and also the intellectual property. So what is intellectual property? The World Intellectual Property Organization defines it as creations from mind. They can be inventions, they can be literary and artistic works. It can also include designs, symbols, or also names and images used for businesses. Intellectual property, or IP for short, is protected by law throughout the world. There are three types of intellectual property. The first will be patents, and that's an exclusive right granted for an invention. So if you make a machine or a gadget or something like that, you can apply to the US Trademark and Patent Office and get legal protections for your patent for about 20 years. Then you have trademarks. That's a sign that identifies a company, good, or service from those of another. So for instance, Nike's slogan, "Just Do It," is their trademark, and it differentiates them from their competitors like Adidas or Skechers or other shoe companies. And then of course, even like logos that we know of, like the Coca-Cola wave and the red perhaps. And then this was something I found out that was kind of interesting. The Los Angeles Dodgers American baseball team has a trademark over a color they call Dodger blue, which is the color of their uniforms and the hat with the famous like LA logo across the top. So even colors, like very unique or special colors or created colors, could also have a trademark. And then we've got copyright, which we'll focus on today. And those are defined as the rights granted to creators over their tangible literary or artistic works. So why should I understand intellectual property or copyright? Okay, I don't think any of us is quite yet a published author or has a blockbuster, or we haven't had our artwork in big galleries or in the MoMA or a place like that. But nonetheless, there are definitely some reasons where we, at this point of our lives or careers or experience, can understand intellectual property. First of all, if you make things and you are a creator. I had this webinar earlier today, and it looks like I had some writers, a couple of people who did a lot of writing and one person who did art and graphic arts. So each of them, I would say, qualified as a creator. If you create, then you probably have copyright for your work. So this means that whatever you do does have some legal protections. And often you reuse some of or build on the works of others to build on your own work for your college and eventually your professional life. So think about the times you cite sources in your assignments. You are asked to look for information, paraphrase or summarize it, cite it, and include it in the body of your assignments. Well, you're going to make some new points, but basically use the points of others to build your ideas and to support them. So people do that not just with assignments, but also for their creations and their art and other things. You are also more likely to respect intellectual property, yours and the work of others, and reuse it in ethical and legal ways if needed. A lot of times people commit copyright infringement because they just didn't know better or they were unaware of what it was. And also, I'd really like you all to know your rights. You can benefit, profit, and just feel good from your work. So no matter what level where you are with your art or your writings or other type of creations that you do, hey, everyone's got to start somewhere, and you can still, enjoy what you do and benefit fully from it regardless of where you are in your level of experience. Now we'll go into copyright defined. Copyright is defined as legal protections and rights for creators who make an original work in a fixed medium. To best explain that definition, I emphasize certain words within it. So first I'll emphasize the red font letters here, an original work. So what kind of an original work can get protection? Well, you got literary works like poetry, fiction, nonfiction, your thesis, for instance, if you're a graduate student. Literary works also include computer code too, like the JavaScript mentioned in the Google case. So I think they consider those literary works because it's text. That computer coding is all textual. Musical works can also get copyright protection. So your compositions, your performances, and arrangements can also be protected by copyright, like in the case of Drake's or the estate of the music that he sampled, for instance. Dramatic works can also get copyright protection. Also, pantomimes and choreographic works like dance routines can be protected by copyright. Dramatic works could be your screenplay or the actual performance of it. Pictorial, graphic, and cultural works have copyright protection, so you can have a copyright for your logo that you created using Adobe Photoshop, the photographs that you had taken, whether it's for your own personal collection or because you want to do creative works with photography, and also cultural works like designs, textiles, beaded jewelry, and things like that may also have protection. And then, of course, motion pictures and other audiovisual works can get copyright protection. Sound recordings and architectural works are also included. The second part of our copyright definition has to do with it being a fixed medium. So a fixed medium is defined as a work in a tangible form. If you can see it, taste it, touch it, and smell it, well, it could probably get a copyright, and it's considered in a fixed, tangible form. One thing that most people don't know is that once an idea is tangible, it has copyright. Now, if I have a brilliant idea for a poem or something like that, I really can't get a copyright on my idea. I have to write it down on paper and have it in an actual tangible form that somebody could see. Then it has copyright and its protection. Registering a copyright is required for legal purposes. So for instance, if there's a lawsuit or an infringement claim, a copyright would have to be registered with the United States Copyright Office. But otherwise, registering for a copyright is not mandatory to be able to have its general protections. I often get questions about when a person should register their copyright. My suggestion, according to what I've read and what I've heard from experts, is if you expect to make money on your work or commercialize your work, you may want to have copyright protection through a registration. Also, if a lot of people have similar ideas to you, getting a copyright protection may put a timestamp on it and show when you had this copyright and maybe give you an initial first claim on this particular work. So I'd say those are probably the main reasons you may want to register your copyright. Now we go for the third part of the copyright definition, defined as legal protections and rights for creators who make an original work in a fixed medium. The third part of this definition has to do with the rights that creators have because of copyright. So when you have copyright, you have the right to copy or reproduce your work. Nobody else really should be able to unless you give them permission. You can also share your work or distribute it. So for instance, if you paint something or create something, you can share it with other people if you see fit. You can also prepare derivative works. What does that mean? Let's just say I wrote a book. Well, I think the book's kind of interesting and funny, and I decide I want to make a movie into it. So then I take the book and write a screenplay on it based on the plot, the characters, and everything else in my original book. So preparing a derivative work is what you're allowed to do with the copyright. Another example of a derivative work may be, let's just go back to the example of my novel that I wrote that I think is funny and interesting. Well, let's just say people in other countries really liked it too, and they want it translated from English into their respective language. Well, the translation is considered a derivative work. So I would have the rights to say, yes, we can translate my work into Japanese or Spanish or another world language. Creators also have the right to display the work. So if they have art or photography, they can have the right to display it. For those who do music or poetry, they could also perform the work publicly when they have the copyright. Believe it or not, when people perform other people's music publicly, and especially at a venue where people have to pay, like a concert, they usually have to pay a licensing fee to be able to perform it, known as a performance right. And another right that creators have is their ability to transfer their copyright. So for instance, there's agreements where, let's just say I decide I want my novel, my great wonderful novel, to be translated to Spanish and Portuguese. Well, I could give a publisher that publishes in those languages like limited rights to translate my work into their language and distribute it in Spanish and Portuguese speaking countries. So that's an example of transferring some of my copyright. I'm not giving it to them completely, but just a little bit of it. And then copyright holders can also give their copyright away, which often happens when people publish in a professional or academic journal. All right, is there any questions so far? I see I got a few people here, so I just want to make sure everybody has all the information they need before we go further. We just gone over the definitions of the copyright and the rights that they give people. And I just wanted to also remind the person that came in a little late that this recording will be available on the library's YouTube page within a day or two. So now we'll go into the protection and time span of a copyright. Copyright protection is provided for a length of time, so it's not forever, and it really depends on the following factors. It really looks at the format of a work. So is it a book, image, music, sound recording, or other types of work? Because of the many changes in copyright language, because of the changes in copyright law over the years, that really affects how long certain types of works have copyright. The year of its creation also influences how long it has copyright protection. So things that were created in 1950 or 1960 will have a shorter copyright protection time than things published nowadays or created nowadays. And once again, that's because of the changes in the law, many that have been made over the years. The country or where a creator was when they first made a work will also determine copyright protection time. Like, let's just say I go to a sabbatical and I'm in Israel or someplace else, and I publish or create something while I'm there. I would have to take a look at what the copyright protection terms are in Israel, especially if I plan to start to publish and distribute my work while I'm there on my sabbatical. So that's something else you need to take a look at. These can be determined by looking at copyright laws on some authoritative web pages. I do provide some references at the end where you can find this kind of information. And then you could also take a look at a works copyright statement that will let you know when it was published and when they had the copyright, because then that will help you determine how long the copyright protection is good for. There isn't necessarily a rule of thumb in terms of copyright protection. And as I've mentioned, you definitely want to check current copyright sources for that information. However, here's the current terms for recently created works, and that's pretty standard right now. So works that were made 95 years ago or more would be in the public domain. That means that it does not have copyright protection, so nobody has to worry about asking permission to reuse or do something with the copyrighted work. This year, Winnie the Pooh entered the public domain, so anyone could make Winnie the Pooh shirts and designs and books if they want to, and the original creator of Winnie the Pooh or their estate really can't do much about that. Works made after 2002, for a person who creates a copyrighted work, their copyright is good for the duration of their life plus 70 years after their death. So let's just say somebody created something yesterday and got it published, and they pass away in 2050, for instance. Well, add 70 years to 2050, 2120, that's how long the copyright rights are for that work. It goes to basically his or her estate or their heirs. For corporate works or things made by a corporation, it would be 95 years from the publication or 120 years from creation, whichever expires first. Sound recordings published after March 1st, 1989 also have the same length of protection as works made after 2002. And so do architectural works made from December 1st, 1990. Now, a lot of people wonder why it's so long. Well, what happened was that copyright holders were interested in supporting their heirs, like their grandchildren and so forth, with their works. And then also corporations had an interest in maintaining their copyright for long periods of time. So now we'll go into some myths and facts that I commonly hear. So hopefully these little myths and the facts that are presented will help debunk some of those that are out there. One common thing that people assume is this: I need to label my work with the copyright logo for it to get copyright protection. Okay, so thinking about what we just mentioned about copyright, is that true? Go ahead and take a guess in the chat if you'd like. So the myth states that if you write a play or you publish a photograph, you need to put a little C logo with a circle around it and then your name. Okay, Tiffany says no. Okay, and so does Mev. Sorry, don't know the pronunciation off the bat. Okay, so a work gets copyright protection the moment it is tangible, so you don't necessarily need to label it. Now, I have read some things to say it's labeled, it's recommended that you label it just to ascertain or document that you do claim a copyright over that particular work as of that time. So if somebody sees it on the internet, for instance, they want to reuse it, well, then they can get in touch with you and they know who did it. But otherwise, it's not mandatory. Registration is not mandatory either, unless it's for legal purposes, or if you, and it's not mandatory, but it's recommended if you plan to commercialize your work. Myth number 2. I also have to register my work with the Copyright Office. Well, we just answered that. It's not required, but necessary for legal situations like a lawsuit or an infringement claim. So for people who did not register their copyright but want to claim someone infringed on their work, a lot of times they have to quickly get stuff registered before they could sue somebody for a copyright infringement or ask them to take it down. And then here's a third myth and fact. I kind of feel like it's a slightly unfair question because I didn't expand too much on this before, but the myth is this: I own the copyright for all of my work. So what do you think about that? What do you think the fact is to that statement? I own the copyright for all my work. Okay, one person says no. Let's see. I actually had that question myself as an FAU employee. Do I own the copyright for my work? So depend on if you were the only creator or if someone contributed a lot. So copyright can be shared and divided. So let's just say you wrote a song and somebody co-wrote it with you. Well, chances are they would also, legally speaking, be the copyright holder besides you. Also, if you're hired to make or do something for someone else, it may be considered work made for hire. So let's just say you're an independent artist and you specialize in making logos. Well, depending on the contract that you may enter with the client or someone who hires you to do the work, it might be considered work made for hire. I'll give you some more information about that on a research guide that we have so you can learn more about work made for hire. Any questions so far about anything we just went over? In terms of the question about me being an FAU employee in my work, I discovered that by norm, as opposed to policy, when an academic or scholar publishes a paper or presents a poster or something like that, they would actually have the copyright for their work. But things like my teaching materials or my slides, like what I'm presenting here, that may actually be considered property of FAU and not necessarily my own. So yeah, we really have to take a look at the fine print about who owns what, especially when you're supported by a company or an entity to do that kind of work. All right, so we're going to transition into the topic of fair use. What is fair use? Well, let me explain with these two images here. Back in 1999, I believe, there was a movie out called Scream. It was rebooted in 2020, but I think basically the plot and the characters and all of that remained the same. It was about a small town of Woodsboro terrorized by this psychopathic killer that was just targeting random people, it seemed like, but they all knew each other. So that's the movie Scream, kind of like with that big scary mask there toward the top middle of the page. Then you see to the lower right of that, there was a movie that was released about a year after Scream's original in 1999 called Scary Movie. So you see how they kind of made a pun on the mask, and then you see that kind of somewhat scared guy holding up the "I see dead people," referencing the movie, oh gosh, the M. Night Shyamalan's movie. I can't remember the name of it, but it was about that little boy that he said, "I see dead people." Well, anyway, Scary Movie was a parody of Scream, and it basically took a lot of cliches from horror movies and just put them all together in one movie, Scary Movie. So Scream being converted to Scary Movie is an example of fair use, where somebody, well, I think it was actually the Wayans brothers parodied Scream into their own production. So in a way, that's kind of an example of fair use. But there's a second example of fair use in these two silly images in a way. I'm using these two images, which were meant to inform people about this new movie to come out and to get their interest, and also to brand the movie. Well, these images were converted into an educational, teachable moment, like what I'm doing now, to show you, well, this is an example of fair use. So fair use can be used for different purposes, especially for teaching and instruction purposes, or in the case of the Wayans brothers production on Scream, a parody or a new creation of something that was previously done. Oh yes, Sixth Sense, thank you. So I made a mention about the guy looking kind of goofily scared, holding a shirt, "I see dead people." Yes, that references the movie The Sixth Sense with Bruce Willis, that's right. Thank you very much, Sarah. Okay, so now we'll go into fair use, a definition. Fair use is a part of copyright law known as an exception or exemption that allows the limited use of works protected by copyright without permission of the copyright holder. So I don't think the Wayans brothers had to go ask the producers and creators of the movie Scream to do that movie. They were able to do it because it was a parody, and as far as I knew, they never got sued for it. Fair use is outlined in the current US copyright law, US Code 17, Section 107. Fair use applies for limited and transformative purposes when using copyrighted items like movies, images, books, and so forth. And what does limited and transformative mean? We will see. It can be in instances of commentary and critique. So we're probably familiar with music reviews or movie reviews or even critical reviews of literature and works of art, perhaps. So fair use is where people can take a copyrighted item, and even though they're not copying the whole thing, they could still take it and comment and critique on it, like on its merits, its shortcomings, its challenges, what it adds to the body of knowledge or creation. So fair use is often used when commenting and critiquing things. You actually use it in your assignments every time you're asked to get information sources, paraphrase, and use it to support your points or create a new point. Fair use is also used in the news. That's why you see all the different networks saying pretty similar things when reporting on things that happen day by day. And then parody. So kind of like the Scream and then Scary Movie instance, fair use can apply when it comes to parody. Another famous person that does a lot of parody is Weird Al Yankovic, who had parodied the music of Madonna, Michael Jackson, James Brown, and even the rock band Nirvana. As far as I know, he's never been sued. If anything, I think one of the people who he parodied had said, if your work was parodied by Weird Al, then you truly made it. So fair use is another instance, and Weird Al is definitely a great example of fair use in his parody. Now, although copyright law protects intellectual property, fair use gives some allowances to using works protected by copyright without permission. So for instance, it allows us to make parodies. It allows us to cite and quote works to support our academic or scholarly works. It allows us to repurpose things that were created into something new or different. I took this picture here on the left of this pink polka dot bus. This was done by an artist in the Detroit area named Tyree Guyton. What he did was he would find basically discarded items around the Detroit area and make them into art. What he did in this case was he took an old bus, I don't think it functions, but he turned it into art, painted polka dots, created some collages around it, and put it in a vacant lot just north of downtown Detroit. So he's basically repurposing this mode of transportation, which initially took people place to place, into a work of art. And he definitely had a message to convey with using that. This goes beyond the scope of this presentation, but that's an example of taking something and making a different use out of it to make a statement. Fair use was also added to law because if we limit things too much, then you really don't allow other things to grow, so to speak. I mean, you really may limit ideas and expressions and new creations from being made if there's too much restriction. So fair use, to go to the second bullet on this page, does allow some copying, sharing, clipping, and repurposing, but it depends on the details and purposes of the use. So as I'd mentioned, the transformative, parody uses, news, and commentary and critique are the big things that happen because of fair use. So these broad tasks and examples utilize fair use and consider a fair use analysis in making the decision to use other work. When you copy and share something, it may be considered fair uses in some circumstances. In this example, my student worker Jean scanned her senior photo from prom and prints it out for grandmother, who frames it so she has a picture of all her grandkids on her living room wall. I mean, it's only the grandmother who has it. It was Jean's copy, and she could do that. Even if it was a professionally done photograph, Jean may have some ability to do that, and it may constitute fair use if it just ends up on her grandmother's wall. Teaching and learning uses fair use a lot. So as I mentioned earlier, you summarize information from an article or other source, use it to support your point, and cite it in your assignment. That's an example of fair use. Or if your professor gives your class a copy of a book chapter to read in your class, that's another example of fair use, especially if your professor really needs you to read this to get a point, or they're trying to teach you something about a topic in your class. Personal use. So Hector downloads Baby Yoda wallpaper from the Star Wars site and uses it as his PC screensaver. That also constitutes fair use. It's just for his own personal use. He's not going to sell it or claim he made the Baby Yoda himself or anything like that, or try to sell it. It's just something he downloaded from the internet and he used it just for himself. And then remixing or repurposing. So the internet search engines is a really big example of this. When I found out, I was really surprised. So internet search engines take information from web pages and reorganize it as search results. So Google, for instance, does not own or have copyright over all the billions of web pages that it searches probably every day, perhaps. What it does instead is it takes the metadata from these web pages, just the descriptive terms that describe what people can find on the page. Then it kind of like takes it, distills it, and then gives it to us in the search results. So that's an example of fair use. The social media sites really rely heavily on fair use, and so does technology, kind of like how that Google versus Oracle America lawsuit kind of like backs up. So doing these broad tasks and other circumstances might not be considered fair use because of the details of use. So for instance, I mentioned that if your professor gives your class a copy of a book chapter to read in the class, and it's face-to-face, that's usually going to be fair use. But if your professor gives you a copy of an entire book that he, I guess, decided to do all the copying and gives it to you all, that may not be an example, highly unlikely to be an example of fair use, and it's because of the details. That is how much of the book he used. A fair use analysis will help you consider if your intended use of a work is protected by copyright. You can determine if fair use applies, if you should get permission to reuse a work, which you can do, and maybe they'll grant you permission to reuse the work. You could also change how you use a work for it to be fair use. Like for instance, with this movie posters I used, I made a very small version compared to the much bigger version that it really is. That may change the details. You could also use a different work, or you could also do something completely different than use a copyrighted work. So to do a fair use analysis, you're going to look at 4 factors, and I'm going to briefly describe them here before going into detail. You got to look at the purpose of use. Why are you using it, and a work's character. You'll take a look at the amount or how much of the work you want to reuse. Are you going to sample like a 10-second sound recording from a 7-minute song? Or are you going to use the beat of that particular song that makes everybody know what it is, like kind of like that Under Pressure song by Queen? They eventually sued Vanilla Ice, the rapper, for using, for sampling some of their beats from their song, and settled at an undisclosed amount of money. Then you'd also take a look at the nature, type of work you're using, and the effect or reuse on a work's demand or marketability. Sounds like a lot, doesn't it? But we're going to just try to break it down for you a little bit. And I also have a form that you could use so that you can think about making a fair use analysis. So fair use analysis objectively reviews the 4 factors for a given situation. I like to put these 4 factors in an acronym that I call PAIN: purpose, amount, nature, and effect. The 4 factors describe considerations for whether or not a use weighs towards fair use or does not. So for instance, looking at number 2, the amount and proportion of the work used, you're going to ask yourself in your analysis how much of an original work can be used in proportion to the original work. Is it a significant amount, or is it the heart of the work or the most significant content? Now, I'm not going to go over all these in full detail. I can give you a link to the form at the end, but you can see factors that weigh towards fair use, like using small portions of a work, less significant amounts, or the less significant content of a work. However, things that weigh against fair use, now I'm not saying they completely eliminate fair use per se, is if you use a whole work, a very large amount, or the most significant content or the heart of a work. Fair use, however, is a balance of these factors and not necessarily numerically determined. So you can say, oh, well, 3 of these factors weigh towards fair use and 1 weighs against. It's fair game. Well, not necessarily. You kind of have to balance it out. I like this form because it's kind of like a checklist. I like to see that if I have more things on the left side, the pluses, then more things on the right. Okay, maybe I can consider it being like weighing towards a fair use. If I have too many things on the right, maybe I want to change the details, use something else, get creative. But your fair use decision will also depend on your tolerance for risk. Some people are very frightened of getting an infringement notice and getting sued. Some people feel more confident about their fair use, especially if they've used it a lot or learned a lot about it. And they feel like maybe they can defend themselves against an infringement claim if that happens. So really the fair use decision is really up to you and your tolerance for risk. The fair use checklist is available at this particular URL. I'll put that in the chat now so you can keep it for yourself. And you can, 3.3, okay, good. Okay, and then you could get going with trying out a fair use analysis or seeing how it works for you. Okay, so we'll go into a couple other myths and facts. Every time I want to use a work for educational uses, I can because of fair use. Yes or no, true or false? Myth or fact? Every time I want to use a work for educational uses, I can. What do we think? Well, first of all, these all or nothing phrases like every time or always, those are always a little suspect in questions and statements, but let's see. Not necessarily. The type of work and other details of using it may weigh for or against fair use. So in the instance of the instructor copying a chapter for his class that meets face-to-face may weigh for fair use. Whereas if a person gets a scanned copy that they found on the internet and distributes to their online class, well, chances are it may weigh against. So just because somebody wants to use something for instructional or educational purposes doesn't mean it's always going to be fair use. And your fair use analysis is very important to determine this. Now we'll go into copyright infringement. And this isn't necessarily to frighten you into never using copyrighted work again, but just so that you're aware of what it is. And for those of you who make your own work, what you could do about copyright infringement. Copyright infringement is taking on the rights of a copyright holder when you don't have them. This image that you have here of a guy with DVDs on boxes kind of reminds me of something I'd seen when I was traveling abroad. I was in a Caribbean island when I noticed street corner vendors that were selling DVDs. Now the covers were very similar like this, these really cheapy covers you'd see like at CVS or whatever. And they photocopied the covers of DVDs and slipped them in. These actually look much better than the ones I'd seen, but you get the image, you get the picture of what I was looking at there. So copyright infringement and the rights, this is what it looks like. When somebody copies and distributes copyrighted protected works, that's going to be an example of infringement. So that's like the street vendor with these probably bootlegged DVDs. Making derivatives is an example of copyright infringement. So let's just say you wrote a work, you wrote a novel, and then you find that somebody had created it as a graphic novel without your permission. Well, that's infringement too, when someone makes a derivative of your work without your permission. Selling it is also an example of infringement when they're not supposed to. Displaying it. So artists do have rights to display their own work. So unauthorized exhibitions and displays are considered forms of copyright infringement. And then performance. So as I mentioned, when people perform music on stage and for money, they usually have to get public performance rights for it. But if you don't get that and you sing and you want to get paid for it, that's another example of copyright infringement. Copyright infringement is both a legal and ethical issue. It's like taking or using property of others without permission. So it's almost like, let's just say I want to go to New Orleans, but I don't want to put the miles and wear and tear on my car. So I just take my neighbor's car, don't ask her. Well, a lot of people would consider copyright infringement as something similar. Not only is it kind of like ethically not a good thing for me to do, but legally, I think it'd be considered theft. It's also having works be used without permission. And when this happens, the copyright creators or owners miss out on the benefits of the work. They don't get the esteem for their efforts, and they don't get the profit or the other kinds of benefits for their work. The law can inform us and we can try to apply copyright in good faith, but ultimately the courts make the decision about infringement. So now as I go into consequences, like I said, I don't want to frighten you out of ever using copyrighted works again for very ethical uses or ones that really do a good faith fair use analysis. But I just want to let you know, like the consequences tend to begin from like low grade, and then they kind of work their way up the ladder based on intent. But copyright law and infringement is defined in United States Code Title 17, the Copyright Code of the United States. So initially what will happen for copyright infringement is you may get a takedown notice. I had a friend a few years ago who got a takedown notice because she had a web page and she downloaded a bunch of songs on there for her friends to download. Well, some companies got a hold of her and said, you have X number of days to take this down, or we're going to take further action. So she didn't want to get in trouble. She took it down right away. Then the next step will usually be some sort of a civil action. So it might be impounding, where the copyright holder gathers the infringed works and then either destroys them or makes the infringer turn them over to them. The copyright holder could also file a lawsuit for damages, kind of like in the case of Drake or Oracle. There's also the Copyright Small Claims Court that was recently established to handle the cases of just regular people who create, maybe not necessarily people in the big time who are represented by large attorneys or corporations or companies there. But there's more information about that. They're still working on the details for Copyright Small Claims Court. Then for large-scale infringements, there may be criminal proceedings for copyright infringement done within the first 5 years of the infringement. Infringement done for profit or commercial advantage with retail value of more than $1,000 may result in a criminal proceeding, and also a fraudulent copyright notice. That is when you willfully claim a copyrighted work as your own. So one more quick fact and myth: infringement is no big deal. Recording artists and movie stars are already rich. Well, I don't know what you've read about from the music industry, but that's not necessarily true. Many recording artists and those in movies say infringement and piracy deprives them of billions of dollars every year. I hear a lot of musicians say that they have to tour constantly and release multiple tracks before they even start to see profits or rewards from their music. It's just gotten so easy to distribute music electronically that a lot of recording artists don't see that they profit like they did 20, 30 years ago. It's your choice, but if it was your song or movie, just to put ourselves in another person's shoes, would you like to be denied credit and money for your creations? So, hey, that's just for us to consider. So in conclusion, copyright was created to give creators incentive for creating their work and ways to protect their work. And really today's goal was to help you make good decisions, but also to be aware of your rights. So we want you to be able to flourish, benefit, create, and be happy with what you do, for sure, but also debunk some copyright myths by using some authoritative sources for your intellectual property and copyright questions. If you'd like more information on copyright, we do have some research guides available to you. If you go to libguides.fau.com, we do have a few copyright guides that you could look at that go further into fair use or work made for hire. For those of you who are into creative works, we have a page just for you called Copyright for Creators. And then for people who do a lot of teaching and learning and instruction, we also talk about copyright from that perspective. On the web, you got the US Copyright Office at copyright.gov. That's where you can get information about the law and registering your copyright, but it also provides circulars, which are kind of like condensed sources of information for different types of copyright for protected works. And then the copyright term in public domain from the Cornell University Libraries helps you determine if a work may be in the public domain. Stephen Fishman also wrote some really good books on copyright that are available here in the FAU libraries. If you need help, go to the library homepage at library.fau.edu. You can access our chat, text, and email so that you can ask us questions if you want. And you can also request a consultation or even a presentation. We can meet with you one-on-one, face-to-face, by phone, email, or Zoom, or contact your campus library or library department. So for those of you who are here and need to take the quiz for extra credit to wrap up, I'll put the quiz link to in the chat here. The quiz covers content in this particular webinar. I'll also give you the copyright research guide because a lot of the answers there, well, a lot of the answers on this quiz are available on this guide. Sorry about that awful tappity tap sound. So once you take the quiz from the 10 items, results will be sent to you within a few minutes. You could get a certificate for answering 8 out of the 10 questions correctly, or 80%. You can take the quiz multiple times if you'd like, but just wait till you get the first result and then see if you need to take the quiz again. Okay, so this concludes the copyright and fair use basics, math, myths, and facts. My name is Christy Padron. I'm the Scholarly Communications Librarian here at the FAU Libraries. Before I conclude, were there any final questions that anyone had regarding copyright, fair use, or anything covered, or even anything about the library that I could answer while everybody's here? Okay, if not, I'd mentioned that the quiz URL is in the chat. Also, the fair use analysis URL is in the chat as well. And then the research guide if you would like some more information. So other than that, thanks for joining us for this FAU Libraries Fair Use Week copyright activities. If you have any questions, let us know. Thank you and have a good rest of your day. Okay, bye-bye.